Good morning. Are you Veronica Randall?
It's Gianna.
And Ms. Randall was previously in court and caused numbers 25 DCCR 0246 and 0247. Entered pleas of guilty to theft of property with previous convictions, a state jail felony. Also entered pleas of true to prior convictions, which enhanced this to I believe, second-degree felony for punishment purposes. The agreement was for a cap of...
Right from the start, this case carries some serious weight. Veronica Randall isn't just facing a single mistake. She's standing before the court with decades of criminal history under scrutiny. The big question is, can someone with this many prior convictions convince a judge they've finally changed?
Cap of 6 years in prison. I've received and reviewed that pre-sentence report. Have you all both had an opportunity to review that report?
Yeah, Sean.
Yes, sir. Are there any additions or corrections to the report?
All good? What you read? All accurate? There we go. No additions.
Judge, I don't have any additions or corrections. I would just state if it's the appropriate time for the court. When I look at it, I have some empathy for Ms. Randall based on the comments that she made. But how much can we take her out of her word with her criminal history? The court will recall you previously rejected 4 years in this case. I'll defer to whatever you think appropriate. Yeah, Judge.
I also have taken judicial notice of the jail incident reports. You both should have copies of those. Have you both had an opportunity to review those as well?
Yes, sir.
Yeah, Sean.
All right.
That's an important legal detail. A sentencing cap means both sides already negotiated limits on the punishment. But don't let that fool you. Judges still have significant discretion within those limits, and the defendant's history can heavily influence where that sentence lands.
Mr. Vasquez, you may proceed with argument.
Gianna, I know Ms. Randall's had probation a couple of times in the past, and it didn't work out for her. But I'm arguing for anything that does not involve incarceration. Ask the court to just grant her probation with every condition, and that the court thinks best would help her to quit offending. And in lieu of that, in the alternative, you're not asked for something less than the 6 years. If she
Defense counsel is making a last-ditch effort for probation instead of prison. But here's the challenge. When a defendant has repeatedly violated the law over decades, convincing a judge that this time will be different becomes an uphill battle. What do you think? Should courts continue offering chances for rehabilitation? Or is there a point where enough is enough?
Anything else, Ms. Malfini?
Judge, I don't have any additional comments. I would just state that our agreement initially was to dismiss the new case because she already has the sequence felony priors. That would enhance anything further, but if the court disagrees with that, we can visit about it after the sentence.
So, Ms. Randall, I made some notations on this pre-sentence report, some issues and maybe some mental health issues that have contributed some issues in the past. However, there's nothing in here that makes me believe that any condition you may have is what requires or makes you go out and do what you've done. Literally since 1981. Your first theft that I have here.
This is the moment everyone in the courtroom has been waiting for. Listen carefully to the judge's reasoning. Sentencing isn't just about the current offense. It's also about patterns of behavior, public safety, and whether prior opportunities for reform have worked.
Was from an arrest from 1981. Then I have one after another misdemeanor thefts through 2018. Then we've got, starting in 1986, a robbery and a theft. And then we've got 13 felonies since then. These are your 14th, 15th, and I guess 16th felonies. At some point, you got to figure it out. There's opportunities when you are not incarcerated and not on probation to get the help that you need if that's what you think is the problem. I think the problem is you just like to go steal or rob, because I mean, we've got robbery, aggravated robbery, another robbery. It's
Wow. That number alone explains why the judge's tone has shifted so dramatically. The court is essentially saying that this isn't an isolated incident. It's a lifelong pattern. In sentencing hearings, a lengthy criminal record can often outweigh arguments about personal struggles or difficult circumstances.
anyway, so at this time, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you also entered your pleas of true to those prior convictions freely and voluntarily. In cause number 25, DCCR 0246, find sufficient evidence to find you guilty, and at this time find you guilty of theft of property with previous convictions. Find the other previous convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25, DCCR 0247, I'm also going to find sufficient evidence to find you guilty, find those prior convictions true, sentence you to a term of 6 years in the institutional division of the Texas Department of Corrections. In cause number 26, DCCR 0312, find sufficient evidence to find you guilty and find all those counts true, and in that case, sentence you in accordance with your agreement.
Now here's a legal term many viewers misunderstand: concurrent sentences. Even though multiple lengthy prison terms were imposed, they run at the same time rather than one after another. That distinction can make an enormous difference in how much time someone ultimately spends behind bars. After hearing this entire history, do you think the sentence was fair, too harsh, or too lenient? Let us know in the comments.
Agreement to a term of 20 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0313, find sufficient evidence to find you guilty, find those prior counts true, and at this time find you guilty of unlawful possession of a firearm by a felon, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 26, DCCR 0314, find sufficient evidence to find you guilty, and at this time find you guilty of abandoning or endangering a child, find those prior convictions true, sentence you in accordance with your agreement to a term of 35 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.